Hello, Ayesha. Am I audible?
Yes, sir.
Yes, sir, you are
Okay.
audible.
Okay. Now you can start program.
Shall I start the program now?
Yeah, yeah.
Yes, yes, Aisha.
We are baffled by the term intellectual property rights. When we hear people talking about IPR, the common man thinks that it is something meant for a very serious inventor only. It is not so. Good morning, everyone. I am Aisha Yasin Bhagwan, and I welcome you all to the one day interview collegiate workshop organized by Ismailsaheb Mulla Law College Satara in association with Legal Services Clinic IMLC and IQAC IMLC Satara on intellectual property rights by respected Dr. Dhananjay B. Sutar. I would now like to request our principal ma'am, Dr. Sujata S. Pawar, principal, Ismailsaheb Law College Satara, to address the welcome. Over to you, ma'am.
Thank you, Aisha. Good morning, everyone. Let me welcome today's resource person, Dr. Dhananjay Sutar, on behalf of Ismailsaheb Mulla Law College, Legal Services Clinic, and our IQAC cell. Welcome, sir. Today, we have organized this one-day webinar on a very important topic of intellectual property rights. It is the buzzword of today's world. In fact, whether it is a result of human labor or human brain, it is very important that it should be recognized as property. And in today's information age, this has received remarkable attention from everyone at regional, local, national, international, global level. Intellectual property rights is the area where anybody with his talent can can get the recognition. And intellectual property rights has been given due importance in the academic arena also by various evaluation agencies also, and what students are achieving in terms of IPR, students, faculty members, and the alumni, their achievements in IPR are being treated very substantially by all the evaluating agencies as one of the learning outcomes. And therefore, IPR has become a buzzword now in academic area also, in academic institutions also. And therefore, even we have thought of arranging a lecture, expert lecture on this topic of intellectual property law. It has been made a part of syllabus for law students, and it is a part of many other curriculum which may be at UG level and PG level or even otherwise are very important for students. And we have invited a very uh, well-known and famous personality to speak on this subject of IPR. Let me welcome Dr. Dhananjay Sutar and briefly introduce him. He is currently working as Deputy Librarian in Barrister Barasaheb Khardekar Knowledge Resource Center, Shivaji University, Kolhapur. His academic achievements are commendable. He has done NCOM from Shivaji University, Kolhapur in 1997. He has completed BLib and Information Science from Shivaji University, where he stood first in merit with distinction in 1998. He has done Diploma in Information Technology from CDAC, Pune, in February 2000 with A plus grade. He has done MLib and Information Science from Shivaji University, again with first rank in November 2001. He has completed NET as well as SET and has completed PhD in Library Information Science from Shivaji University, Kolhapur in 2015 with outstanding grade. He has done his PhD under the title Impact of Information and Communication Technology on Library and Information Science, LIS Education in Universities of Maharashtra. He stood 8th in the merit list of HSC board as well and has a brilliant academic career. He has secured first rank in his graduation levels. He has 19 years of experience as a librarian in senior college, and he was assistant librarian in Balasaheb Khardekar Knowledge Resource Center from April 2013 to March 2015. And since 2015, he is working as deputy librarian there. So he has 15 years experience as contributory lecturer as well for Enlightenment and Information Science program at Shivaji University, Kolhapur. He has also provided counseling to various programs at various universities and institutions, including Bapuji Salunke Mahavidyalaya Miraz and Vivekanand College Kolhapur, C.V. Shah Mahila Mahavidyalaya Sangli for the guidance to students appearing for NET and SET in library information science. Several students of MLib course submitted research project dissertations under his guidance. He has participated in 3 orientation and refresher courses and also participated in more than 30 workshops, orientation programs, seminars, conferences, and symposiums. He has delivered more than 45 guest lectures on different topics in library information science. He has published 5 books on this subject and has also worked as editor for several scholarly proceedings. He has completed 2 minor research programs which were sponsored by UGC. He has published 36 research papers in national, international journals, and conference proceedings. He was honored with C.D. Sharma Award for Best Paper at 62nd International Conference, which was organized by Indian Library Association in the year 2017. And he has been a very consistent writer in newspapers as well on this very important topic. So once again, I welcome you, sir, on behalf of our college and request you to guide our students regarding intellectual property rights. Thank you.
Thank you, ma'am,
Thank you
for
so
your
much,
nice
ma'am.
introduction. Okay.
Now, I would like to request our today's resource person, Dr. Dhananjay B, Sutar, Deputy Librarian, Balasaheb Khardekar Knowledge Resource Center, Shivaji University, Kolhapur, to tell us about intellectual property rights. Over to you, sir.
Okay, dear participants, very good morning to all of you. And as Madam in the introduction has given you the idea behind organization of this webinar on intellectual property right, that all of the students must know that you are the students of the law, and this is one of the topics those have been included in your curriculum. But it is not only limited to the law, but as an academician, every teacher, every professor, as well as every student must know what actually the intellectual property right is. Because in the field of education, whenever you are going to make use of information, that use of information is related with improving your knowledge, because the quantum of the information that is supported to you in your education process, that determines the level of your knowledge. If you are getting the right information, if you are getting the very nascent information in the right time, it does have impact on the level of your knowledge. And that is what the relation of what the information is, how it is converted into the knowledge, and how that knowledge ultimately leads you to the wisdom. But while dealing with all these details in an academic environment, those are related with the teaching, learning, we are also engaged in the process of the research. Now teachers are teaching you, but their research is continuing. In the field of sciences, where they are inventing new things, there comes certain aspects related with the intellectual property rights. Many of the students, after completing their higher education, when they are engaged in the process of the research, either as a PhD student or in the postdoctoral research, they are going to invent new things which may not be invented before that in the society. And sometimes the research is so qualitative that whatever the output that comes, that needs to be protected under copyright law. Or sometimes whenever a new invention in the field of product has been taken place, it has to be protected by the patent. And that's why whatever the topic that has been chosen today by the organizing committee is very important one. Every student as well as the lecturer must know what actually the intellectual property right is, and accordingly I am going to make the presentation related with that. So PPT has been prepared by me. I will share this PPT later on to Mugi sir, and you can have access to that. So this is the PPT which I am going to present you. Mugi sir, can you see this? Hello?
Yes, sir.
Okay, we'll start with what actually the intellectual property right is. Now, actually IPR refers to creations of the mind. Now, creations of the mind means as a student, you are involved in the process of teaching, learning, as well as curriculum, and along with that, you are also involved in the research. So, whatever the creation of mind that will take place in the form of the inventions. Inventions means those things which are not in existence, we are going to invent it in a new way. Those are called the inventions. Sometimes there might be the outcome in the form of the literary and artistic work. Any new book you may write, any new article you may publish, that will be your own contribution in the field of your subject. So that is called the literary works. Artistic works are also there, as well as some of the symbols, names, images, and designs are used in the commerce. So that is the creation of the mind, and that is to be protected under the IPR Act. And that's why IPR is a general term which covers three important aspects. First one is related with the copyright, second one is patents, third one is trademarks. Now, geographical indications are also considered as one of the part and parcels of IPR. Now, when you are going to think about IPR, we have to take into cognizance all these three aspects, all these three terms which are related with copyright, patents, and trademarks. Now, categories of the intellectual property or industrial property, it includes inventions. Now, for inventions, you have to file the patent. You have to take the patent. Then trademarks, industrial designs are also there, and geographic indications of the source are also included under the intellectual property. Now, one term is there which is related to the copyright. That this is the term which includes literary and artistic works. You know that literary work consists of the novels, poems, plays, and artistic works includes the films, musical works, dance performances, and it may also include the drawings, paintings, photographs, sculptures, and architectural designs. So whatever that come under the purview of literary and artistic work, that has to be protected by the Copyright Act. Now these are the rights related to copyright, which include those of performing artists in their performances also. Then producers of the photographs in the recorders, and those of the broadcasters in their radio and television programs, all those are related with the copyright. Suppose one particular radio program is there, or whatever the television program that is broadcasted, that is also coming under the purview of the copyright. Now, whatever the sound recordings, music recordings, or video recordings are there, those are also protected under the Copyright Act. And the artists who are performing their activity in front of the people, now their performances are also considered to be the part and parcel of the copyright. Now, what this actually copyright is? So, copyright is a legal term which describes rights given to creators for their literary and artistic works. It means that when the person has produced any literary work by himself, now suppose if a particular lecturer or if a particular student, he has created a literary form. Now suppose if a student is a poet and he has published a book of his poems. Now that book is protected under Copyright Act because the copyright goes to the author. Sometimes the author transfers that copyright to the publisher, and for that purpose he may get some benefit in the form of royalty from the publisher. So that particular work which has been newly created by a particular author is protected under Copyright Act. So it is not only related with the literary work, it is also related with the artistic work. Now drawings, paintings or photographs, etc. that can also be protected under this Copyright Act. So it is a statutory privilege. It comes under the gamut of provisions of the law. If others are going to make use of the work which has been created by you, it may result into the infringement of the Copyright Act. And that's why we have to take into consideration why this is essential to get protected your work under the copyright. Actually, it is the statutory privilege extended to creators of the works that are fixed in a tangible medium of the expression. Now, tangible medium means the medium which you can see, in which you might have expressed something, and that has been created by you. So you will get a statutory privilege against that. Now, suppose one particular author has written a book, but before publication, he may keep the copyright of that particular book with him, so that other people cannot copy that book and sell it out to others. They have to take prior permission of the author, and only then it is possible for them. So we will see some important provisions related with this copyright. And here comes the importance of this Copyright Act. Now, what the importance of Copyright Act is? Actually, it respects the intellectual rights of creators of the information. Whatever the new information that has been created by a particular person, because for creating the information, that person is engaged in the research. Actually, creation of the information is the outcome of the research. It is the outcome of the deliberate efforts that have been made by the creator, and that's why it respects the intellectual right for the creator of that information. It also rewards the creativity of the authors, artists, musicians, etc. Now, the role of the author, role of the artist, role of the musician is different. They are creating their own output in their particular field in various forms related to their area, and copyright provides reward for the creativity for them. So it is also a legal mandate that once when you have taken a copyright of a particular thing, that rests with you and others cannot make use of that, otherwise it will become illegal use. And that's why it has a legal mandate, and there is a moral proper behavior for the students, teachers, as well as other members of the education community. That is why whenever you are going to make use of the information which has been created by the other, you have to take into consideration what are the provisions those are related with that. Now, suppose if I have written a particular book which is really in demand, and if the same is going to be published by other author, that will not be accepted, because that those ideas those have been expressed in the book, that the theory that has been developed in that particular book, and that whatever the practices those have been mentioned in that particular book, that is the outcome of the creator of the author, that is the author. And that's why whenever we are going to make use of that, there is a proper behavior for the students, teachers, as well as other members of the educational community. And that is what the importance of the Copyright Act is. Now we will consider what comes under the purview of the copyright and what does not come under the purview of the copyright. Now, as I have already mentioned, that literary and artistic works are coming under Copyright Act. Now, literary work, you know that it may be a novel, it may be poems, it may be plays. Now, many times the author of the play creates the book or the play, but when it has to be performed on the stage, the producer of that play has to take a prior permission from the author of that particular play, that we want to make a public demonstration of your play, and we have to get the permission from you. So that is what the importance of it. Then there are various reference works. Basically, these reference works are referred to by many of the academicians for a particular piece of information or for its reference for their research work. Now, whatever the information that has been published in the newspapers or whatever the computer program, those are there. Then databases, those have been provided to majority of the readers, wherein the related information is made available to the academicians. Then the films, musical compositions, and choreography, which is related with the dance steps, those all are coming under the purview of the copyright, so that can be protected under Copyright Act. Then there are some artistic works which may include a particular painting or the drawing. So basically, drawings are very important in the field of the engineering. Then photographs and sculptures are there. Then architectural designs are there. Then whatever the advertisements and the contents of the advertisements are there, as well as maps and technical drawings. Those all are covered under the Copyright Act. But if it is a particular idea which has not been kept on the paper and which has been communicated only to one another, that will not come under Copyright Act. Then whatever the fact that is there, that will not be covered under the Copyright Act. Now sun rises to the east, that is the fact. Our earth is round, that is the fact. So that information will not come under the Copyright Act. Then recipes are there. Basically, the methods related with the recipes are common, and that cannot be protected under Copyright Act. Then some blank forms are there. Whenever you are going to fill up the forms anywhere else, in the banks, in the government institutions, in the libraries and in the colleges, whatever the blank form, those are there for filling up the information, those are not protected under copyright. Then whatever the stock and literary devices, those are there. Then words lacking originality, that is phone book. Then the names, titles or short phrases, then words from the federal government, that will not be covered under the Copyright Act. Now we have to take into consideration what is the limitation of the copyright and what is the duration for that. Now as far as limitations on the copyright are concerned, whatever the reading material, that is a literary work that is available, if that is going to be used in the library and in the classroom for the teaching, it is called the fair use of the material. Fair use means what? The purpose behind creation of that particular artistic work or purpose behind creation of that particular literary work is that whatever the material that has been mentioned there, that has to become useful to the people. If it is an educational book, the contents of the book are useful to the teachers and students. So if you are going to make use of that for our education, it is called the fair use of that particular material. So that is the limitation of the Copyright Act, that libraries can make use of that, and classroom exemptions are there for fair use of this literary and artistic work. And thereby comes what is the duration of the copyright. Now copyright in a literary work, it lasts for the author's lifetime. Now if a particular work has been created by the author, then the copyright of that particular book, poem or drama, that remains with the author in his lifetime. But after his death, from the end of the calendar year, next 60-year periods is also counted from the year following the death of the author. So up to the next 60 years, the copyright will remain with that particular author. And after 60 years, that particular literary work will come into the public domain, that anyone can make use of that particular literary work without taking into consideration whether it is copyrighted or not. After 60 years from the date of the author, the copyright of that particular book will come to an end. Then for films and sound recordings, the period is 50 years. After 50 years, those films and sound recordings can be used by people anywhere else to whatever extent. And for typographical arrangements of a published edition, it is related with the 25 years. Now, whatever the material that is made available to you, which has been copyrighted by the author, how much you can make use of that material, that you have to take into consideration. Now, for that use, you need not have to take the permission from that particular author, even though that material has been protected under Copyright Act. Now, for the text which has been copyrighted by the author, you can take up to 10% of total material that is available in a particular book, or 1000 words, whichever is less. And that's why, if you are aware with Plagiarism Act, now recently UGC has provided the notification and has passed the UGC regulation 2018 related with maintaining academic integrity and prevention of the plagiarism, wherein they have given 4 stages, that up to 0 to 10% level. If the similarity of the text is found, only then and then the PhD or MPhil thesis or the research article is accepted by the university or by the concerned publisher. Otherwise, what happens if the text is going above 10% from the total text that is available? It will become infringement of the copyright law. And that's why there is one provision which is related with making use of the literary work from the books and journals, that the similarity shall not go beyond 10%. And that's why this limit has been set to 10%. Now, whatever the material that is available in the book, out of that only 10% you can make use of, or 1000 words, whichever is less, you can take as it is, but you have to be sure that you have to make citation of that particular source, that these are the lines or this is the material which has been taken from this source, and you have to give weightage to the originator of that particular information and has to mention in your article. Now, as far as motion images are concerned, there is a period for motion images. It might be a clip of 1 hour or for 40 minutes or whatever that may be. So out of the total quantum, you can take up to 10% or 3%, 3 minutes only. More than 3 minutes of motion images taken by the person who is not originator of that particular work will lead to infringement of the Copyright Act. And that's why the motion images up to 10%, or for 3 minutes or less than 3 minutes, you can adopt as it is without the permission of the author or the originator. As far as music is concerned, up to 10% of total quantum, or 30 seconds or less than 30 seconds, you can take as it is for any purpose. So whichever is less, that you have to take into consideration. For photos and images, up to 5 works from one author. Now suppose one particular photographer has made a snapshot of 100 photos. You can take only 5 photos out of that. Up to 15% or 15% works, whichever is less, from a collection. Now 15% means out of 100 photos, 15% will become 50 photos, 15 photos. Or up to 5 works from one author, means 5 photos. So in that case, you can, from that particular collection, can take 5 photos or images for the purpose of your use. So whichever is less means either 5 photographs or 15 photographs. Out of that, 5 photographs are less, so that you can adopt as it is. And then whatever the database information that is there, that is again related with the provision related with the text, because you know that database contains the information. Database is defined as it is a collection of the information with related information. In educational complex, we are going to make use of the various databases. Those are made available to you either by the college or the university. So you might have heard about the Scopus database or Science Direct database. In the field of laws, there might be other databases. So if your library is going to subscribe to these databases, the access to databases is provided either with the IP access or through username password. Then from that database, the information up to 10% or database contains the fields. So 2500 fields or cell entries, whichever are less, those are to be taken into consideration by you for your use. Now suppose if in case of motion images, your use is going to become more than 10% or 3 minutes, or if it is exceeding the limit that has been displayed on this PPT or slide, If that is going to become more than that, then what you have to do? What you have to do is that you have to take a prior permission from the creator of that particular motion image or a text or a music or the photos or the database, and after getting the prior permission you can make use of that, so that will not be infringement of the Copyright Act. So be alert that whenever in your research, whenever in your research paper, whenever you are going to become a student of the PhD or MPhil in the future, all these limitations you have to take into consideration. Otherwise, many times you will be in trouble. That it has become mandatory now that whenever you are going to submit your assignments, whenever you are going to submit your dissertations or the thesis, you have to go through the process of plagiarism checking. And if the similarity will be less than 10%, only then and then your assignment or your thesis or dissertation will be accepted by the authority, otherwise not. So in order to avoid all these things, you have to take into consideration what percentage or what is the duration within which you can make use of a particular source of information. Now comes the concept of the trademark and patents. We have covered the copyright. Now we have to take into consideration what is trademark and what is patent. Actually, trademarks, it is a distinctive symbol, distinctive name, motto, or design that legally identifies a company or its product and services, and sometimes prevents others from using identical or similar marks. Now take for example, there is a trademark for McDonald's, there is a trademark for Coca-Cola, there is a trademark for many of the products that we observe whenever we are going to make use of that, or whenever you are going to see the advertisement on any media. So there is a distinctive name. Take for example, Parle-G. This is the name of the biscuit which has been popularized all over India. So you cannot produce another biscuits making use of the same name, that is Parle-G. Now what other traders have given is that if it is the spelling like P-A-R-L-E capital G, they have given as P-A-R-A-N-E G. One A has been added. So the trademark of P-A-R-A-N-E-G is the original one, but P-A-R-A-N-A-G is another one, but they have not adopted the spelling as it is, so it is not an infringement of the act. They have created their own trademark. So the previous Parle-G will remain as it is. Now the people have to think that which product they have to buy. So it is a distinctive name. There is a distinctive symbol also. Take for example, for Tata, there is a T. The round of the T is in half circular way, and there is one line in between the T. So that is the symbol of the Tata. So others cannot adopt as it is as the symbol for another product. So there is a motto or a design by a particular trader, so that legally identifies the company and its products and services, and we cannot take into consideration their design, their symbol, their motto as it is. So if that will be adopted by you, there will be infringement of the act and punishment will be given to you. As far as patents are concerned, so patents are nothing but the exclusive rights which are granted by the government to make use of an invention or process for a specific period of time. So it is a legal right which has been confronted by the government to the originator of the invention. So for getting the patents, you have to fill up the form, has to provide it to the government, and after providing that, the government will issue a certificate that the patents of the particular invention lies with you. So the person who has got the patent against his invention will get some benefit in the form of monetary benefit. So this is the official website of the IP, that is ipindia.government.in_patent.htm, wherein if you will go, you will find a form. If you have made any particular invention, you have to mention that into the form. You have to fill all the details, and after that they will provide you the patent certificate. So this is the sample patent certificate. I have downloaded it from the Google image, and that's why the matter that has been described here is somewhat not clear. But you can go to Google and find out the patent certificate and can see. You will see that there is a logo, there is a proper signature which has been given. So it is a certificate given by a government to the originator of the work. Then comes geographical indications. See, geographical indications of the goods are also defined as that aspect of the industrial property which refers to the geographical indication referring to a country or to a place situated therein as being the country or place of origin of the product. Now you will come to know that Kolhapuri chappal. So Kolhapuri is the geographical indication. So it signifies that whatever the chappal that has been produced, if it is Kolhapuri, then it is unique one. Okay. Then we can see basmati rice. Rice is there, but if it is basmati, it is different. So from that particular geographical area, it might have been identified. And that's why when it is being indicated referring to a country or to a place situated therein as being the country or place of origin of the product, that is to be protected under this act. So typically, that particular name conveys an assurance of the quality and distinctiveness. That you know that Kolhapur chappal, Kolhapuri gul आपण त्याला म्हणतो. Then Satarचे कंदी पेढे. You are from Satara, that's why I have given you the example. So that itself signifies, that itself conveys the quality of that particular product and distinctiveness, and that assurance is given to all. And that's why it is essentially an attributable to the fact of its origin in that defined geographical locality, region, and country. In the country like India, in a particular geography, it is known for a particular product or a service, and that has been supported with that. And that's why geographical indications are coming under the purview of IPR. So in India, India has enacted these geographical indications of goods, that is part of the Registration and Protection Act 1999, has come into force with effect from 15 September 2003. So some of the important aspects related with this, I am going to inform you that you have to take into consideration what is actually intellectual freedom means. So intellectual freedom is the right of every individual to both seek and receive the information from all points of view without restriction. So even if this intellectual freedom has been given to you, even then, sometimes you have to take into consideration the provisions made in the law. So this intellectual freedom provides for free access to all expressions of ideas, through which any and all sets of question, cause, or movement may be explored. But while enjoying the intellectual freedom to seek and receive the information, you have to also take into consideration the provisions that have been made under IPR. Because if that information is copyrighted, then you cannot take more than 10% or 1000 words, whichever is less. Accordingly, we have to take into consideration the aspect of the censorship, which is the suppression of the ideas and information that certain persons, individuals, groups, or government officials find objectionable or dangerous. Now, in any of the book or motion pictures or photographs and other things, there might be some political content, there might be some sexual expression, or there might be use of language offensive to some people's racial, cultural, and ethnic background. Then gender and sexuality has been considered, or political or religious beliefs are there. If you are going to include any content which are objectionable or dangerous, which will result into creation of the social conflict, then that work is protected under censorship. There is a censorship board that determines whether it has to be made available to the public or not, or to ban it. So accordingly, those materials which are considered heretical, then blasphemous, seditious, then obscene or inappropriate for children, that have often been censored. Basically, before release of the movie, after publication of the book, there might be ban on that particular book because that is censored. whatever the information that is covered is objectionable and dangerous. So in order to maintain the social justice, social equality, the censorship board take into consideration certain aspects. And misinformation is incorrect or misleading information presented as fact, either intentionally or unintentionally. So all these things are having some relevance with the intellectual property right. Now, as regards the validity of the IPR, patents are protected for maximum 20 years. After that, you can make renewal of the patent every year, which is mandatory. Trademarks, maximum protection, there is no limit. It is lifelong for you. But after 10 years, you have to make the renewal of that. As far as designs are concerned, the protection to the design is given for 15 years. But after completing these 15 years, after 10 years for the next years, you will get the renewal. Then comes copyright. Copyright material, as stated you earlier, that author will enjoy the copyright even after his death for next 60 years. So there is no renewal required. And geographical indications are also the maximum protection is given for lifetime. But after 10 years, you have to renew it. So you can go on renewing for a lifetime period as far as the geographical indications and trademarks are concerned. Then some of the important things which are useful for the teachers community, as we mentioned, that there are some specifics on the fair use. So what exactly can teacher do? I said that whatever the reading material, whatever the research material that is available, the teachers are making use of that because they have to communicate the information contained in that particular book or a particular source to the student for increasing their level of knowledge, for increasing their level of more information, because the quantum of information affects the level of the knowledge. If the students will get more information, they will become more knowledgeable. Vice versa, if they will not get the sufficient information, they will not get more knowledge. And it is called the fair use that is made by the teachers in the process of teaching, research, as well as lesson preparation. So that specifics are there that a teacher may copy. He has the freedom to copy one chapter from a book. He can copy one article from a periodical or a newspaper, short story, short essay, or short poem. He can copy chart, graph, diagram, drawing, cartoon, or picture from a book, periodical, or a newspaper. But he may not copy to create or to replace or to substitute for anthologies, compilations, or collective works. He has given a freedom to copy to teach in the class, but if he is going to develop a particular philosophy, he is going to compile the information. If he is going to make the collection of the work, that is not expected. So copy from the consumable products, copy to substitute for purchasing resources, copy at direction of superior, that is the principal copy, same item each semester, they cannot make use of that. For every semester, they have to go on changing the information contained in that. And that's why the teacher may make multiple copies for classroom use if only one copy of each item per student is made. Suppose if there are 20 students, he can prepare 20 copies and distribute it to the students. But 20 students are there, he has prepared 40 copies, that is not accepted. So each item copied is for classroom discussion. So whatever the multiple copies he has prepared, that must be for the purpose of the classroom discussion and not for distribution to all. And that each copy includes a notice of the copyright. Each item meets the 3 tests for the copy. So that he has to mention that this is the copyrighted material. He has to mention there. While providing that material to the student, he has to mention that this is the copyrighted material and its circulation among public is to be prohibited. Then as far as internet materials are concerned, unless specifically stated, everything is copyright protected on the internet. Many times we go to the image, we go to the text, we copy it and paste it for preparation of our assignments, for creation of the projects, but that is not expected. So fair use guidelines are applied. You may not take material from one site. Abundant material you cannot download from one site. You cannot repost it to another internet site, or you may post on a protected school or district intranet. So it may include links to other sites under implied public access and not overall public access. So on the internet of your library website or on your college, only some links you can provide instead of providing the whole material. So the students will click on that link, they will through the subject gateway go to the original portal, and from that portal they can have access to that particular information. As far as multimedia projects are concerned, moving images, video, laserdisc, DVD, still images are there. So all these are multimedia projects where there is a combination of audio, video, or audio video. So they can make use of that, but to a limited extent, as mentioned earlier. So students may make use of copyright rules in multimedia projects, perform and display multimedia projects for their academic assignments, include their multimedia projects in electronic portfolios for assessment purposes only. And they can also invest in the copyright free images, music, and video clips created especially for multimedia projects. They can use royalty free images, music, and video clips available on the youths. Now, some of the laws I will consider. This is for your information, just an overview of the all laws related with the IPR. As far as trademarks are related, there are two laws. The first law was passed in the year 1958 and it was entitled as Trade and Mercantile Marks Act. So it is an act that provides for the registration and better protection of the trademarks and for the prevention of the use of fraudulent marks on merchandise. Now, second law was carried out. It was known as Trademarks Act 1958. So this is the original one, which was passed on 17th October 1958, which again amended in 1999 to amend and consolidate the law relating to trademarks. So it provides for registration and better protection of trademarks for goods and services and for the prevention of the use of fraudulent marks. As far as patent law is concerned, the Patent Act was passed in the year 1970, in which change was brought out on 30th December 1994. Again, the Patents Amendment Act was passed in the year 2005, which was passed on 4th April. Now, the Copyright Act was carried out, passed in the year 1957, and up to now there are amendments which have been made in the 1983, 1984, 1992, and 1994. So, it is an act to amend and consolidate the law relating to copyright. The Geographical Indications of the Goods Registration and Protection Act was passed in the year 1999 on 13th December. So it is an act which provides for the registration and better protection of the geographical indications relating to goods. Now, geographical indications means that particular goods and services which have been produced in that particular geographical area will gain more popularity. So the Design Act 2000, it was passed on 25th May. It helps to consolidate and amend the law relating to protection of the designs. And next one is Protection of the Plant Varieties and Farmers' Rights Act 2001, which was passed on 13th October. So this act provides for effective system for protection of plant varieties. Many of the scientists, with the combination of 2 or 3 seeds, they are going to create new varieties of a particular plant, new varieties of the flowers, new varieties of the fruits, and the rights and farmers and the plant breeders, for them it provides the protection to encourage the development of new varieties of the plant. So that can also be protected under this Protection of Plant Varieties and Farmers' Rights Act 2001. So after this discussion, I will come to the conclusion that for copyright to apply to a work, it must be an original idea that is put to use. So if you want to get the copyright, whatever you are going to produce, that must be the outcome of your original idea. So since this IPR is a legal mandate, it is compulsory for all to consider the provisions of the IPR law. And basically, when you are in the field of education, as a student in the process of learning and as a teacher in the process of teaching, you must have at least overview of this IPR law. So whenever you are going to rely on the idea developed by the others and the physical use of that idea, that is covered under the copyright law. If you are going to make use of that as per the limitation that have been set, you will not be in a trouble. But if you are going to exceed that, then it will create some difficulty for you. Because once when it has been identified by the particular originator of the idea, he may file a case against you if you have made infringement of that. So hence, whenever you are going to copy something from the internet or any printed material, whenever you are going to distribute it to the others, whenever you are going to make any changes in that, and whenever you are going to display it for creative, literary, and other types of work, the like IPR law is to be considered very sincerely. And that's why what I feel is that what the importance of this IPR lies in the field of education is that whenever you are going to make use of any artistic work, whenever you are going to make use of any literary work, you have to become aware of the provisions related to the copyright, patents, as well as the trademarks. So this is the overview of intellectual property right. After all, there are so many legal provisions related with these laws. If you go in detail with the provisions in the law, those are more complicated, but you can understand it well. For the purpose of teachers, learners, and only the provisions which can be utilized in an academic environment, I have prepared the contents for this presentation. Now, with this, my presentation is over. That will be followed by the questions if there are in your mind. But before that, I am very much thankful to Ray Shikshan Samstha and Ismailsaheb Mulla Law College Satara for inviting me to have interaction with all of you on the subject of intellectual property, right? I am also very much thankful to Honorable Principal Dr. Sujata Power Madam. She has very nicely introduced to me, as also has made an introduction about why she has selected this topic for the workshop. And as usual, I think this topic aptly suitable for your college because yours are the law colleges. Many of the students from the law colleges have been joined for this program. So I hope that whatever the contents I have shared might have increased your level related with information of IPR. And I am also very much thankful to the librarian and coordinator of this workshop, Sri Anup Mugli, because for so many days he is in contact with me and he has waited a lot for this day because I was very busy one. So I told him that within 10 to 15th of this February, I am not able to deliver the lecture, but he waited for me and accordingly he has organized this program. So I am also thankful to librarian Srianu Mugli as well as all the team members who have organized this program. Thank you so much. Now the session is open for discussion. Yes, any questions? I will share this PPT with Anu, so you can send it to all the participants.
Yes, sir. Yes, sir.
Students can ask the questions in chat box. Sir, may I ask one question?
Yeah, sure, ma'am. Sure.
You said for plagiarism, 10% or 1000 words if you are taking copying from others' material.
Yes, ma'am.
The legal limit allowed.
Yeah.
But as far as law is concerned, many times we have to reproduce the sections taken from the acts and they run into many words. So,
Yes.
is there any special provision for law that such kind of definitions, such kind of explanations, exceptions, provisos, we have to give them verbatim?
Yes,
So,
yes.
whether they can be excluded in this usual limit?
It's a very nice question you have asked, madam. Because many of the researchers they have doubt in their mind. See, in a particular discipline of education, like pure sciences, law, and other things, you have to give the proofs, and for that you have to give the information as it is from other source in your project, isn't it? When you are not going to quote it, it will come under the purview of the plagiarism. But if you are going to quote it with proper reference, then there is a provision in the softwares that determines the similarity that that particular quoted work can be excluded. So there is a provision to exclude quotes, there is a provision to exclude references, and there is a provision to exclude consecutive 14 words, one quote. That provision has been made in that UGC regulation which is related with the plagiarism. And that's why in your law projects, if you are going to adopt a particular case as it is, which might be for 2-3 pages, but if you are going to put it into double inverted comma and going to cite the reference for that, that software can exclude that particular code. So whatever and how many codes you are going to mention in your project, that will be excluded and will not come under the purview of the plagiarism. But whatever the original idea that you are going to write, excluding these codes, that shall come less than 10%. So that provision is available. Again, for the pure sciences, there is a provision to exclude materials and methods. Because see, in the science field, it is well known fact that H2 is equal to water. So everyone will write H2 is water. So that can be excluded from the plagiarism. So there are three provisions that you can exclude quotes. Second one is you can exclude references. Third one is you can exclude consecutive 14 words which are similar to the text mentioned with other sources. So that facility has helped a lot because that code you are going to mention to support your research or to criticize a particular idea. So that has been taken into cognizance by the developers of the software that that particular code can be excluded. So that can be excluded.
That was a very useful information.
Yes, yes,
But we have PG students also, LLM
yes.
students who have to give submit dissertation.
But in some of the software, madam, there is no provision to exclude any material. So while acquiring that particular software, you have to take into consideration whether that software provides a provision to exclude the codes and bibliographies or not. So basically, Turnitin and Authenticate are the softwares which are heavily used all over the world, and there has a provision to exclude the codes, references, as well as consecutive 14 words and methods and materials.
Thank you, sir.
Sir, one question is there. I write in chat box.
Which one? Now there is one question I will read so that everyone can understand. While using someone's research or work in a research work or PhD thesis, can we use their work with proper reference? Yes. Answer to the question is yes, because if you are going to provide a proper reference, then you can use that particular work. See here, what you are doing, you are taking their reference in your text, but at the same time, you are going to provide the due weightage to the originator of that particular work, and that's why it is legal one. So when you are going to quote a proper reference for that particular work, it will be under the jurisdiction of the IPR. Or put a question type, next question is, or do we need to do something more than just mention the reference? Now there are another aspect that one particular theory has been read by you. So if you have made your own contribution on thinking on that particular idea, and if you are going to put it in your own words, so that is also acceptable. Actually, that is what the research is. That whatever the theory you have read, after reading the theory, whatever you have understood, if you are going to apply your knowledge on that understanding and you are going to create a new idea, that will be your own contribution. So that is more appreciable than quoting the word. After reading a particular theory, if you are going to think on that at your own, you are going to put it with advanced theory in your own words, then in that case you do not have to give the reference. So these are the two questions and these are the answers, that if you are going to adopt as it is, give the reference. If you are not going to adopt as it is, but you are going to put it in a refined way, then there is no need to give the reference. Yes, any more question?
I think there is no question on chat box of YouTube also, sir. If anyone students have any query, please ask on chat box.
Now these two questions are so important that I think the answer to these questions have covered so many important aspects, especially plagiarism.
Yeah, sir. Yeah. I Aisha. Yeah. Okay.
Yes, sir.
There is no question.
Yes.
Please continue.
Looks like there are no questions. Yes, sir. Looks like there are no questions as you have covered everything that is under the sun, sir. Thank you so much for explaining today's topic, that is intellectual property rights, in such a lucid manner. I would now like to request Sri Anup P. Mugli, Librarian and Coordinator, Lead College Program, IMLC Satara, to present the vote of thanks. Over to you, sir.
Thank you, Aisha, and good afternoon, everyone. I am Anup Mugli, coordinator of Lead College Program, in front of you to propose vote of thanks on behalf of Rayat Shikshan Samstha, Ismailsaheb Mulla Law College, Satara. First of all, I express my sincerely gratitude towards today's resource person, Dr. D.B. Sutar Sir, Deputy Librarian, Barrister Barasaheb Khardekar, Knowledge Resource Center, Shivaji University, Kolhapur, for accepting our invitation of this program and guided us on the topic of intellectual property right. Sir guide us intellectual property, copyright, how to use copyright. Also, sir, guide us on trademarks and patents. Thank you, sir, for this intellectual fees for us. Also, I express gratitude towards our principal, Dr. Sujata Pawar ma'am, for organizing such a wonderful and informative webinar. I am thankful to all students, teachers from all law colleges for their participation. I am also thankful to our teaching and non-teaching staff to make this program success. Last but not least, I am thankful to Aisha who anchoring this program very nicely. Thank you one and all. With the prior permission of the principal ma'am, here I declare that this program is over. Thank you, sir. Thank you so much.
Thank you, sir. Thank you so
Have a
much.
nice day.
Oh, have a nice day, sir.